The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Seated. We are here this afternoon for 3 separate cases to be argued. We are going to take a brief recess between the first and second case. The first case, looks like the lawyers are ready to go. Benda versus Prairie Meadows and Iowa Horsemen's and Iowa Thoroughbred Breeders. And it looks to me like Mr. Lantz is the one who's going to be arguing. Is that correct? Yes, Your Honor. You may begin.
Thank you, Your Honor. May it please the court, counsel. Along with Tyler Smith, I represent Terry Benda, who's in the courtroom today. Our legal system does not resolve disputes, particularly class action lawsuits, based on speculation about what could happen if a judgment's entered against a defendant. Here, the district court relied on multiple layers of speculation, blatant and admitted speculation about what could happen if Prairie Meadows is forced to account for the underpayment of certain bonus payments due to owners and breeders of Iowa-bred racehorses, and that was an abuse of discretion. The proper remedy, which is not speculative at all, is to certify the class action and, at worst, to allow the owners and breeders to decide for themselves if they want to seek recovery of those underpayments. The foundation for the district court's order denying certification was its erroneous conclusion that virtually all of the proposed class members actively oppose this lawsuit. That conclusion poisoned the district court's analysis of all of the class certification rules. And there are many problems with it. First is the antagonism that the district court relied upon was admittedly speculative. This is exactly what this court identified in the Cragness case as the type of motivation or concern that should not drive a district court's decision on class certification. The district court can't deny certification merely because some people are...
Difference, Mr. Lantz, because in Cragness the class was certified below, here it wasn't, and we have a deferential abuse of discretion standard.
True as the procedural posture, but reading Cragness, the court clearly says over and over that when the concern is rife with speculation, that should not be the sort of concern that allows or drives a decision on class certification, which is consistent as well with multiple federal authorities that are persuasive in this context as to not looking to hypothetical concerns. Astoundingly here,
here is you have organizations that represent most of the putative class members, and these organizations are opposed to certification. But my question to you is, was there a membership vote?
And in fact, that was significant to one of the layers of speculation here is that the district court conflated essentially a dozen people running these organizations with 850 class members. Neither the ITBOA nor the IHBPA can say to you how many of their members are actually part of the putative class. It is purely a guess. Neither organization surveyed its members or had a vote. In fact, this is driven home by the testimony at the class certification hearing of Maggie Moss. The most successful horse owner in the class period was never even aware of this underpayment, much less the lawsuit or claim. Not consulted at one bit until, frankly, I called her days before the class certification hearing, and she testified to that. The ITBOA, the court found, has 400 members. It actually has 260 if you count husband and wife, maybe 330-ish. But even then, it includes things that are not breeders and owners. They can't say, even in 2020 or 2021, how many of them are part of the proposed class. The IHBPA has more members, but it represents trainers and people that are not part of the proposed class that own non-Iowa horses. Neither organization speaks for the quarter horse owners or breeders as well. And yes.
Is it to show the numerosity and define what the class is?
Burden to show numerosity. And in fact, the Prairie Meadows' own records here show and identify the names. All we did was count. And that doesn't require any special expertise. And we counted 847.
What should we make of the fact that through summary judgment, all your claims have been dismissed except a breach of contract claim, if I understand. And it's a written contract between Prairie Meadows and one of the associations, and they're both opposed to this class action.
A couple of things on that. First of all, the IHBPA's position in that as to that contract is not dispositive. It's the clear language of that contract that governs what it means. The IRGC has determined what the clear language of it means, and that supports our client's claims.
Action was about the contract, or was it about the statute?
But the contract language mirrors it. Additionally,
Contract be subject to theories of extrinsic evidence or waiver, possibly? One of the briefs makes reference to the idea that there could have been waiver or other course of dealings, or because of this Rasmussen formula was the way it was done between the parties, right, or the way it was understood.
He suggests it. There were the ITBOA came to the IRGC with a completely different position, which was many Iowa horse owners and breeders didn't share the position the IHBPA has put forward. And they said, this is being portrayed as it wasn't a controversial issue. It very much was, as to this 20% requirement. And here's another important point, Your Honor, is regardless of how the 20% requirement is interpreted, the evidence shows without contradiction, Prairie Meadows underpaid the class. Because the 20% requirement, if you follow the IHBPA's analysis, and this is what we laid out in our reply brief, that it applies only to purse supplements, and even if you apply the Rasmussen formula, it's about 1.6 million underpayment in just 3 years. Additionally, the 2015 contract, which is a separate contract but also part of the claim, there the 20% requirement definitely includes breeders within it, and our expert, Mr. Totagamua, testified without contradiction, even applying the Rasmussen formula, there's an underpayment.
Did that go to other pockets then of possible class members?
Clear, in the sense that they want to argue that there is other people that were overpaid. That assumes, in fact, that there is an 11%, that is the only amount that's ever paid out by Prairie Meadows. Prairie Meadows has a minimum percentage of its calculated net win that it is required to pay towards purses and bonus payments that gets allocated in a number of different ways. But Prairie Meadows could have paid more than the 11%. So this is the zero-sum problem. They're assuming and speculating that if the class had been certified, there would be other people that would have to lose money. That is, no party here has indicated, and Prairie Meadows has not alleged a claim, that there is any party that they could seek recovery from. They've not articulated that claim. It's only being hypothesized and accepted by the district court, though, as a given reality. Additionally, there's not a valid legal theory, particularly one that escapes statute of limitations at this point, for how Prairie Meadows could seek any pay from any horse owner that received a base purse previously. Another layer of speculation here had to do with the district court's finding that the Prairie Meadows would pay for a judgment here by subtracting or taking it out of future purses. There is no legal ability, and no witness has explained how this could happen, no lawyer has explained how this could happen, because the formula for Prairie Meadows to calculate the total amount that goes towards purses and these bonus payments is set by statute.
Of review with respect to the findings of fact.
Has discretion, well, as to the findings.
Certification decision, but what is our standard of review as to the findings of fact?
The Butte case indicates that this court, that the allegations in the complaint are to be taken as true. The court clarified that in the Combs case, Your Honor, and it said that, in fact, unless there are purely the findings, the facts supporting are purely speculative, the proponent's burden is light, which goes hand in hand with the position that we think there was procedural error in the court's findings, that there would be some sort of offset. That's another reason why this antagonism concern that drove the district court's finding.
Contract theory, exactly. Is it an intended beneficiary theory?
The IHBPA contract with Prairie Meadows provides for the 20% rule.
And is substantive law relevant to the class certification decision then? So if you have a third-party beneficiary theory, there needs to be an intent by the parties to benefit the third party. And here, I take it the party's position is there was no such intent, at least with respect to the way they've administered the contract.
The admitted deposition testimony is that that 20% requirement was intended to benefit Iowa-bred owners, the owners and breeders of Iowa-bred horses. That's the point of this 20% requirement, is to incentivize and reward Iowa-bred owners and breeders. To answer your question more directly about the merits, I think the court has said we don't get into the merits of the class certification stage because typically these hearings are done well before you get to that. Now, the fact there has been a summary judgment ruling narrows some of the claims, and in fact, those aren't necessarily final issues, but we know that the contract theory that is before the court and is part of the class certification record is one of the contract with IHBPA, which leads also to what we think is one of the most egregious factual errors and abuses of discretion, is the district court here made findings that if our action for breach of contract is successful, that will jeopardize the contract itself and put IHBPA and its individual members who negotiated it liable for breach of contract. That finding has no record support whatsoever. It came out of left field. Even the appellees at the district court never even asked for it, and in 160 pages of briefing to this court, no one has tried to defend it. That is a classic example of an abuse of discretion.
Class action certification, though, I mean, ultimately, we have to think about how could this case be tried, and would it be better as a class action, or would it evolve into many trials? You'd agree with that?
Concern, of course.
In this case, Prairie Meadows had several defenses, including like a waiver defense, and I'm wondering how that would get tried in your view.
This is an argument that I think the IHBPA makes in their brief, and we addressed it as to the concern about mini trials. There's not an argument about waiver. There's no claim of modification. In fact, for a modification to have occurred, it would have had to have been approved by the IRGC as to this 20% requirement as well. And it's also not an issue that this mini trial concern is not one the district court relied upon for its ruling. The IHBPA has, we don't think that there is an issue. They try to argue that there would be many trials on the issue of reliance. Reliance isn't an element of the claim. I don't think you get there unless they find there was some modification, which there's no proof of that occurring, particularly a modification that's approved by the IRGC. Even if reliance would be an element of those claims, that also legally does not preclude class certification. Methods and degrees of reliance can vary. Claims are not required to be carbon copies of each other. Class actions are certified when there are common issues of law and fact, particularly those that concern the nature of the defendant's conduct.
1.262 sub 2. The court may certify if it finds all the following: fair and efficient adjudication. The representative parties fairly, it doesn't say lawyers, the representative parties fairly and adequately will protect the interests of the class. There's quite a bit of discussion in the district court's order talking about that the Benda is not an adequate representative party. And actually, page after page after page, line after line, gave quite a few details as to why not. Could you respond to that?
What the court actually says in terms of their findings, I think, is actually quite narrow and specific. The court said he wouldn't be credible or have standing because his position is antagonistic to the class, which again, it goes back to my point about how the intra-class antagonism errors infected and poisoned the rest of the analysis. The district court also said that Benda's litigation and disciplinary history starting in 2016 would make his representation less effective. On that point, the court didn't find he wouldn't be fairly and adequately represent the class. This isn't a popularity contest. This isn't a question of is he the best or best possible class representative. The court did not explain, and now I think addressed the wrong legal standard there, but also didn't explain what it means that he would be less effective. There is persuasive case law cited by both parties here that we think convincingly demonstrates this type of history or litigation background does not disqualify someone from being a class representative. It would be one thing if any of the things that are listed in the district court's order would affect a single claim or defense in this case, but they do not. And that's proven by the fact that Mr. Benda continued to receive these bonus payments, particularly Breeders' Awards, all the way through 2020 and 2021, well after he had had other financial troubles related to his service-related disability.
Distinction to be made between IHBPA members and, I want to get this right, the ITBOA members, in that, if I understand it right, by statute, IHBPA is designated as the party that bargains for its members or negotiates the contract for its members. Is that right?
Statutory authority to consent to the agreement. They have no further function in terms of that by statute in terms of monitoring or enforcing that agreement, as proven by this case. Mr. Benda is the only one at this point that has
troubling to me, and I guess I throw it out there to have you respond. It seems that if the statute designates an association to approve the contract, then it's speaking on behalf and with the authority of its membership. Now, I understand now their position with respect to this litigation, you're saying it's not known, but at least the prior agreements, they do have the authority to speak for the members, and they have the authority to speak for their membership now, and they're saying we're opposed to this. That seems troubling to me.
And I see my time is up. May I respond? Justice McDonald, I think they have the statutory authority that's limited by the terms of that statute to consent to particular agreements. Now, the individual contract rights or claims that their individual members, or many people who are not their members, may have, is not something they are appointed or authorized by any of those members to act upon. The statute does not give them authority as a bargaining agent for claims or the ability to speak in a class action to govern what their members would say, leaving really total, we think, great speculation about what their members, what positions their members would take. Thank you, Your Honor.
It's my understanding Mr. Koopmans going next. Okay.
Thank you, Chief Justice. May it please the court. I represent the Iowa HBPA, which, as Justice McDonald noted, is a statutory authorized group that bargains on behalf of all horsemen at Prairie Meadows, both federally and under state law. I'm going to address two issues, adequacy and commonality. I want to let you know where I'm going because I only have so much time and want to leave time for the other intervener and the party. So feel free to jump in wherever you want. This is also a case where, while the law is going to be argued here, I understand it's very complicated and how everything interacts. So happy to answer questions at any time about that. Adequacy. Mr. Benda is not an adequate class member. There are numerous conflicts, and the law says that if there are conflicts between the proposed class representative and the class, that the class cannot be certified. To begin with, he no longer races horses at Prairie Meadows because his license was stripped by the IRGC. That has implications for his standing, which Stone versus Prairie says matter. I'll get to that in a second. But it also has implications for the kinds of claims and the kinds of arguments he is bringing here.
You could have Darth Vader as a class representative in this case, right? Because it's just math and issues of contract law and issues of legality. I mean, I don't think they even need to call him to the stand in this case, right?
The representation, and so that is significant because the contract here, my client's contract between them and Prairie Meadows, actually in Section 7 states what you do when there is an underpayment. And you don't go backwards and pay people going backwards because no one is promised, no horse owner is promised any individual amount of money. There is a book that says what they will get at any individual race, and there's no claim that that book was violated in terms of the number that was in there. So it's an aggregate amount. And the contract specifically says in Section 7 that you go forward. I asked Mr. Benda at his deposition, why didn't you rely on that section? He said to me, quote, well, that would be unfair to owners in 2012 to 2015 that were no longer participating. How do they recover? How do they recover? In such an instance, myself, I'm not racing. So if he is the only representative and his counsel must do what he wants to do, and he is running away from a remedy in the contract that is there in black and white because it doesn't benefit him, that's a conflict between him and the class.
I mean, the court might say, well, you're right on the merits, and he's not entitled to that relief, right?
This is an issue where everybody intervenes and we all have different parts. He is asking to be the legal representative for the entire class. And so you cannot certify him if he is not acting on the behalf of the class as a whole.
Opt-outs?
Because in cases, again and again, I've always said, if there's a conflict between the Bossard case, for example, Judge Wilkinson said, you can't just do it with opt-outs. I mean, yes, opt-out is one relief valve, but not everyone will educate themselves. Not everyone will hire a lawyer to know what their remedies are. And so it's the court's obligation to look and say, is this person an adequate class representative?
The contract claim does not turn on his credibility?
And which goes to another issue of adequacy. The contract claim does turn on or can turn on what happened during the contract. He knows nothing about it. He did not know about these contracts until this lawsuit was filed. He testified to that. In fact, this breach of contract action that is here today, the only one that survives, was not initially pled. It was amended once they received the contracts. So there are other class representatives who have such knowledge. The other issue is there's conflicts between breeders, and so this doesn't have anything to do per se with Mr. Benda, but there are conflicts between breeders and owners. Currently, Mr. Benda is claiming that the contract, the 2010 contract, requires a certain percentage of breeders' awards. There is no term in that contract that refers to breeders' awards. I asked him at his deposition, can you show me in this contract where breeders' awards are required to be paid out? He could not find any. Mr. Benda is a breeder and an owner, but there are some class members who are only owners. So now he's making a claim based on contract language he cannot find that benefits him that does not benefit anybody else.
It's his argument that the position of the Breeders Association doesn't necessarily represent its members, that there was no survey taken. We don't actually have an understanding of the position of most of the class members.
That's a burden that he has elevated that we do not have here. He has the burden. And when you have this many class members or representatives coming forward, it's not our obligation to show that everyone disagrees with that. 9 of the 11 of the board members of my client are owners or breeders. So if that gives you some context. I'd like to, go ahead, Justice Waterman.
Can some of these concerns be addressed through subclasses?
And actually, let me get to the commonality issue real quickly, because I don't see how that works. So you have a contract which we will contend, this is a merits issue, so not in front of you now, that given the history, the context, the extrinsic evidence, does not mean what the IRGC said the statute means. Those are two different things, right? And the contract was entered into before the statute was enacted. But putting that aside, assume that Mr. Benda is correct about the interpretation of the statute. It is uncontroverted that the Iowa HBPA wanted the statute interpreted the way that Prairie Meadows did it. In fact, the Iowa HBPA is the one that fought in 2015 before the IRGC to keep it that way. Prairie Meadows basically threw up its hand and said, we don't care. We have to give the same amount of money out either way. It was the horsemen who said, no, this is how we want it to be done. So there will absolutely be evidence, I mean, it is uncontroverted that there was a modification of the contract, even assuming the original language was like that. The IRGC said in 2015, oh yeah, keep going another year, how you're doing it, and then change it the next meet. So the IRGC does not save them in that respect. And so the law, and when there's a third-party beneficiary, is, this court has adopted the restatement, second of contracts 311, says that the parties can modify the contract unless the third-party beneficiary justifiably relies on the original promise. So that means we have to go through and figure out what all of these people knew and when they knew it. And we're talking in the abstract, so I think it's beneficial just to go through very quickly some names, because this isn't like a consumer class action where there are thousands and thousands of people. We have one class member sitting in this room her case will appear before you 2 cases from now. So they are people of varying different backgrounds and knowledge of what's happening in this case. So I know you won't have it in front of you, but Appendix Volume 2 page 276. It is a chart of all the different horse owners who received purses and purse supplements in 2012. I'm just going to go down a list and read a few names. At the very top is Maggie Moss. She was the most successful horse owner. And that's in total purses, not just Iowa-bred purses. And as you see in what's called an open purse, which is the races where any horse, Iowa-bred or non-Iowa-bred, can participate, she was more successful by like magnitude of 4 than anyone else. I asked Mr. Benda at his deposition, well, look at those numbers. Does it look like Miss Moss probably benefited from the overpayment of base purses and the underpayment? He said yes. So that's her story. She did not know about this case, as Mr. Lantz said. If you go 1, 2, 3, 4 down, a man named Dick Clark. If in the record, his nickname is Mr. Iowa Bred. If you look, he has a significant amount of purse supplements. He was one of the co-creators of the Rasmussen formula. He was on the Iowa HBPA board when the Iowa HBPA went to the IRGC to fight to keep it the way it was. So his knowledge about the formula, why it is, very specific to him. If you go down all the way to the bottom, one up from the bottom is Mr. Benda there, and you will see his numbers. And 20% of his total purses were purse supplements, and so I'll get to the importance of that in a moment. Again, he had not seen the contracts and knew nothing about their formation, hadn't seen them until this lawsuit was filed. If you go to the next page, page 277, at the second to the bottom, Dave McShane. If you look, almost all of his purses come from Iowa-bred horses. 34% of his purses are purse supplements, higher than Mr. Benda. He is the president of the Iowa HBPA. He does not want this class to go through, but also, again, his individual knowledge. If you go one down from him, Albaugh Family Stables, that's Denny Albaugh. All of his winnings came from Iowa-bred horses. He's the president of the Prairie Meadows board. And finally, if you go to page 285, Alan Poindexter, he is the most successful Iowa-bred owner consistently across history. The record shows that he also breeds the most horses. His horses that he breeds in any given year represent 15% of the entire industry in the state of Iowa. He had just about as high as percentage as Mr. Benda did in terms of purse supplements from out-of-state horses versus Iowa-bred horses. He is on the HBPA board. So every one of these people, when you go into this contract claim, are going to have to be called, what did they know and when? And so this is all, like, it is going to be hundreds of different individualized contracts because of all of this. And you cannot have a class action when there are this many issues at play. And finally, I just highlight the burden. It is their burden. I've never seen a class action in which there is so much opposition as this one. We do not have to prove that everyone in our associations is opposed to it. But when we have put forward so much evidence, and all they can say is Mr. Benda is the only one that wants this lawsuit and no one else, they do not meet that burden. Thank you.
Mr. Lipman?
Chief Justice, may it please the court, counsel. Your Honor, I'll be short because we do have one more person that's going to speak here today. I just want to talk a little bit about class action and about adequacy. Benda's lawsuit, I'm going to describe it as a proverbial sandbox. And Benda climbed into this proverbial sandbox when Benda filed his lawsuit. And so far, nobody that we know of has been willing to play in the sandbox with Mr. Benda, and for good reason. As Judge Rosenberg stated, the purported class foresees a real and major detriment to themselves and to the horse breeding and racing industry in Iowa if this lawsuit is granted class action certification. Yes.
Could you talk about the Cragness case a little bit that Plaintiff's counsel talked about? How does that relate to this case?
In
terms of the antagonism between winners and losers in the class.
Well, I think that to really put it bluntly, I mean, all the money here has been paid out. I mean, we've got people here in the class that are due money, people in the class that have been overpaid, We have Iowa-bred horses, non-Iowa-bred breeders. I mean, we have a lot of people here. And in this case, Mr. Benda represents a very small portion of what that is. And in short, you've got the class members are represented by basically Mr. Ogden's clients and my clients. I mean, we are the class.
I mean, in Cragness, you had the situation where what the city of Des Moines said was, if we have to refund $40 million in franchise fees, we're going to have to turn around and raise $40 million, and that's going to come back on the same people or many of the same people that are getting the franchise fee refunds minus attorney's fees. And we said, no problem, you know, that's speculative. It seems to me it's more speculative here to say that Prairie Meadows, with all the money that it brings in, gives $38 million a year out to, you know, the county and charities and so forth and so on, that it couldn't afford $2 million, which, as I understand the pot of money, they're claiming in the class action. Isn't that more speculative?
I don't think it is, because in that case, you're talking about raising taxes. In this case, I represent the ITBOA. It is possible that granting class certification may subject my clients to being sued, some of them for overpayment. And Mr. Ogden could probably talk more to that since he represents Prairie Meadows, but that's a real foreseeable issue.
But that's a decision Prairie Meadows would have to make. I mean, they could also just say, well, we'll take the $2 million out of all the other money that we generate from the casino gaming every year.
That's their decision. But I'm not sure it's speculative. It's really something that's out there. It's an out there. It's a very real possibility and probably a foreseeable possibility. I'm not going to take too much more time because Mr. Ogden, I want to give him a little bit of opportunity to talk, but the ITBOA actually started this fire, and we wanted clarity in the statute. We didn't want a lawsuit then. Our members didn't want a lawsuit when it was filed, and we definitely don't want certification, and we don't think Mr. Benda adequately represents our interests. To that, I think I'm almost out of time, but I'd like, hopefully Mr. Ogden could say something on behalf of Prairie Meadows.
When you approach the bench and it's already red, but come on up. We hogged some of that time, so. Some people's dream.
Yeah, I don't know, it might be mine. But I'm Dennis Ogden. I'm here to represent Prairie Meadows. And I echo the arguments of my colleagues. And I ask the court to find that no abuse of discretion occurred here, that the judge, in his very well-reasoned order, adequately assessed the factors for class certification and found that it should be denied. If you have any questions for me, I'd be glad to answer them, but I don't want to take up any more of your time.
If the class is, if we reverse certify class and they win, is Prairie Meadows going to be suing individuals for overpayments?
Well, that's a very good question. I'm sure they will do it if they can, and you know, those are merits issues to me. I don't think it should be decided on that either way. You know, Mr. Lantz can argue the merits issues against us, but he won't allow us to argue the merits issues against him. So from my perspective, you know, I don't think that we should be arguing about that. We should be arguing about whether this was an adequate class representative, which he's not, and whether they met the other characteristics that are needed, which they didn't. So that's how I would.
Mansfield brought up about being very, 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 very generous to charities, to the tune of, I think the record was like 35 million or something, and that issue is maybe 2 million. Can you address that?
Yeah, absolutely. One of the reasons why we would need to go looking for people who could pay the money back is because that money, I mean, it's not unusual for people to look at Prairie Meadows as kind of a cash cow, okay? But the fact is, they pay out all their money to charities and to state and local government. If they were hit with a double payment, which is what this is going to be, and they couldn't get the money back from someone else, and you know, we're now, I mean, this lawsuit was filed in December of 2018. We're now years and years down the line, and you know, can we go back and get them? And who knows? I don't know if half of those 847 people they claim they've got have died. I mean, we don't know where they're from or how many of them there are. From my perspective, there's no proof of numerosity here. You can read a list, but you don't know anything about those people. And then they want to argue that we don't represent them or that the ITBOA doesn't represent them because there's only 340 people on their list. I mean, you can't talk out of both sides of your mouth on this sort of thing. So it seems to me they haven't shown an abuse of discretion by the court, and we may be looking at paying less to charities and less to state and local government if this lawsuit ends up going forward. That's all I have to say. Thank you.
Mr. Lantz.
Thank you, Your Honor. Mr. Ogden's right. We shouldn't decide this case based on speculation about how Prairie Meadows is going to pay for a judgment. That's not what we do in our legal system. Yet that's exactly what the district court did when it said that class members would have to pay back money. His argument is an indictment of the district court's ruling. There is just as much evidence about his speculative scenarios about how they would pay for this as there is evidence that they would pay for it with the $49 million in sports betting revenue they had last year. We don't have evidence about that, and that's not how these decisions are made. The Vignaroli case from 1985 from this court is very instructive because in that case, the court looked at intra-class antagonism and said just because some people object to it does not mean it defeats class certification. The objection has to be fundamental, which means it has to go to the specific issues here. And the court said, and quoted from another court, the fact that some members of an alleged class do not favor bringing of a lawsuit will not defeat bringing of a class action. The district court here did exactly the opposite of that without even acknowledging the guidance or binding precedent, actually, from the Vignaroli case. All of the appellees in their briefs and even today want to blame Mr. Benda for not coming forward with other plaintiffs that will join. That is not a plaintiff's burden in a class action lawsuit. It is not in Iowa or anywhere else. In the Cragness case, there's one plaintiff. You don't come, that's not a requirement under the rules or any Iowa case law. And even in the cases where they try to suggest this burden from other districts or other jurisdictions, really what is important is we dispel the notion of intra-class antagonism. We have done that here by deposing the people who have expressed concerns, laying forth that this is pure speculation, that they are from a small handful of people based upon legal impossibilities. In the Freeman versus Grain Processing case, Justice Waterman wrote the opinion there, agreeing with the district court's statement that although the nature and amount of damages may differ for each class member, the central factual basis of the plaintiff's claims is, in that case, the defendant's course of conduct and knowledge of potential hazards. There was a common nucleus of operative fact. We think here, this isn't an individual claim. It is a class-wide breach because you can only measure the 20% requirement by looking at what the total class of owners and breeders was paid.
And since it is a third-party beneficiary claim, he contends that the contract on which you're relying was modified, and therefore the recovery would be limited to those who relied upon the modification. What about that argument?
Number one is the district court did not make that finding. That's not the district court's ruling here in terms of evaluating an abuse of discretion. Number two is there is no proof of modification. No witness has said that they did modify the contract. That's an implied argument on appeal that he's trying to spin evidence to say, but no one, in fact, did that. And in fact, the IRGC, as they have stated multiple times in their brief, has to approve gaming contracts. That would be equally true of modifications. Otherwise, the IRGC's power is nothing, because you could submit a contract to the IRGC and then turn around and modify it. So we don't think that there is actually a requirement for reliance in this case. Even if there is, though, there are classes that can be certified even where there are variances in reliance. The case they rely upon is what's the Annette versus Annette Holdings, Rowland versus Annette Holdings, where in that case it was core issues about the claim itself in a workers' compensation situation, including the nature of the injuries and the care that was provided that went to the very essence of the claim that would vary and require mini trials. Here, there is a central legal issue that predominates, which is whether Prairie Meadows underpaid compared to the 20% requirement. And that's something that can actually only be addressed by looking at the class as a whole, because as everyone has acknowledged in their briefs, this is not actually an individual commitment. It's a commitment that Prairie Meadows made to the class as a whole. And that's why class-wide relief is so important and appropriate here. It can be decided on a class basis.
Contract, like an insurance contract, for example, has to be approved by a regulator. Does that mean that it's no longer subject to regular contract doctrines like the ones that Justice Mansfield was just talking about?
It would go to that extent in terms of all, in insurance contracts particularly, but the Racing and Gaming Commission law, I think, is pretty clear that in terms of those contracts needing to be approved, which is IHPPA's own argument. I don't think there has been proof put forward as to any modification of the contract as a whole. And even if, as we pointed out earlier, even if they're right that the Rasmussen formula is what controlled, the evidence presented and laid out in a reply brief is that Prairie Meadows didn't even comply with that. So that really isn't a dispositive question at the end of the day for the class. Your Honors, thank you for your time. We respectfully request that the district court's denial of certification be reversed. Thank you.
Versus Prairie Meadows et al. Is hereby submitted. We will take a 5-minute recess from the court for the case of Auditor versus Local Government Risk Pool.